And now I'll introduce our presenter for the day. We have Miss Tatia Barnes. She comes to us from the law office of Tatia Barnes Esquire, located in Lower Manhattan. Tatia provides services to New York City residents as well as individuals who own assets subject to New York estate laws. I want to pull up, she actually gave me some other information. I want to make sure that I'm providing what she preferred. I think this is what I preferred. So I'm gonna make sure that I say what she wanted me to say. So she's a New York attorney practicing in probate administration and surrogate court litigation. She's a graduate of Fordham University Law, a former Bronx County prosecutor, and a former civil practice litigator. She specializes in surrogate court accounting proceedings while also assisting clients with probate administration and related filings. She's also incredibly knowledgeable, incredibly delightful, and incredibly giving of her time in general. So I'm going to pass this over to Tatia to tell us a little bit more about estate administration.
Beautiful. Good afternoon, everyone. I am here to give you as much information as possible about the estate administration process. Now, I'm located in New York. I understand that we have people here nationwide. Just realize that some of the terms that I use are specific for New York. I'll try and let you know when they vary, but as mentioned before, you check with the lawyer in your jurisdiction for what applies to your state. So welcome to the nuts and bolts of estate administration. And you're going to find this helpful, whether you're involved in an estate or if someone asked you to be their executor, or if you're just hearing about it. Eventually, you're going to end up with an estate. Not all estates go to court, but if there are any difficulties, that's where you end up, in court. So these are just various photos of numerous courts, surrogates courts in New York State. So the estate process is basically about who, what, when, where, and how much. And of course, it's moving the assets of a person who is deceased from their names into the hands of their heirs, whether their heirs are by will or by law. If someone dies without a will, is what all of the fuss is about. So where do we begin? We begin with the documents. And the first question, is there a will? There doesn't have to be a will for your estate to be handled, but that's where you start. Is there a will? Next, after that, we'll cover a little information about the courts, where to file. And what are you filing? You're filing a petition for the estate. The topic after that will be the interested parties. Who's who? Who's involved? Who's the heir? Who's handling the estate? We call that a fiduciary. There are many more parties. This is a thick topic right here. After that, we're going to cover the assets. Show me the money, but it's more than money, because you have personal property, there's intellectual property, there's real property. So that's a hot topic as well. After that, I'm going to cover settlement. That's settling the estate. Who gets what? And as you can see, it's all about the numbers. So I have a lot to cover here. So let me get down to the basics, the documents. Is there a will? Everyone knows about a last will and testament, but you would be surprised to know how many people pass away without a will. And it's really not that big of a deal, except the court governs the estate more when there is no will. You have to keep coming back to court for permission to do various things. The court puts limitations on the powers of the administrator to protect the estate. So when you hear the term testate, that means that there was a will. When you hear the word intestate, that means that there wasn't a will, I'm going to throw a wrench into this. And if there's a trust, it could be testate or intestate, because if someone created a living trust, but they didn't have a will, and that trust didn't capture all their assets, then guess what? The estate goes through as intestate. In New York, we call that an administration. But it has to go through because those assets are not accounted for in the trust. And other trusts have a pour over will, so that there is a will, so it is testate. Okay, not trying to confuse you all, but I know some people are thinking, well, what about a trust? It depends. So once you know whether there's a will or there isn't a will, then you have to prepare a petition to go to a court and file it. And this, in New York, it would be a surrogate court. In some jurisdictions, it's a superior court, or I think orphans and widows it depends on the state that you're in. But we're all doing the same thing. We're putting in a petition for the estate with the court. So here are just a couple of things. If you are taking notes, these are just a couple of topics for you to jot down, just to make sure you're covering the basics. So when you're going to court and you're filing a petition for someone's estate, whether it's with a will or without a will. Oh, and by the way, in New York, if you're filing an estate with the will, the proceeding is called probate. If you are filing an estate without a will, it is called an administration. In different jurisdictions, it's called probate no matter what, and then they just indicate it's intestate. So check in your jurisdiction what it's actually called. But that's why I started with the documents. Is there a will or isn't there? So the first thing that the court is looking for is domicile. Domicile means, in a nice, easy way of saying it, is where's your home base? Where do you pay your taxes and vote from? So that's your domicile. In New York, it's based on your county. So if you're a New York resident and you're in Westchester or you're in Queens, that would be the county where your will is filed, or your estate is filed. It really goes by the death certificate. And so let's say you were visiting someone out west, if you pass away, and they list their home address as on the address for the death certificate. That causes a problem because all of your assets are here in New York. It gets worked out eventually, but just to get you thinking about it. So you have the domicile, you have the death certificate. The court requires an original death certificate. You can't give them a copy, and they keep the original, so order extra. Then the court also requires the original will and any codicils. A codicil is a written amendment to a will, and they require the originals. There's a lot of case law about lost wills. There are various ways, sometimes under certain circumstances, to probate a lost will, a copy of a will. Just find the original. Another thing that the court will require in an administration, that would be intestate in other jurisdictions, is the funeral bill, and that's to make sure that the funeral creditor has been paid or is aware that the estate is being filed. And next, this one causes a lot of problems. It's the family tree or an heirship affidavit, and we're going to get into the parties, but this basically gives the court a roadmap of the legal heirs. In New York, they're called distributees, people who would take from the estate had there not been a will, or if there's no will. The law dictates that. So the family tree or the heirship affidavit gives the court its first glimpse at who the legal heirs of the decedent, that's the person who's passed away. In New York, we call them a decedent. Who the legal heirs of the decedent are. And finally is the court filing fee. It's statutory in New York. It's based on the value of the estate. In New York, If the estate exceeds 500,000, then you're paying the maximum court filing fee. You always check with your jurisdiction. The court will also tell you where to look. But I would say these are the most important things in a nutshell when you're dealing with the court. There's a lot more to it, but we only have an hour. So next, let's move along. Let's talk about the interested parties. Who's who? Now, the whole purpose, when I went to law school, our professor told us the whole purpose of a will is to keep people out. Right? You thought it's to give and to bring people in. No, it's to keep people out. So let's talk about the fiduciaries first. If you have a will, the person who's going to handle your estate, or rather the person who you nominate in your will to handle your estate, is called an executor. If you're dealing with a trust, and trusts end up in court more often than you would think, your fiduciary, the person handling the trust, is called a trustee. If you're dealing with someone who passed away without a will, then the person handling the estate is an administrator. In New York, a small estate is handled by a voluntary administrator, and by small estate, we just mean an estate where the value of the assets of the estate is $50,000 or less. If it's a penny more, I kid you not, if it's a penny over $50,000, you have to file for full letters of administration. So the person who handles the small estate is called a voluntary administrator. Outside of New York, there are oftentimes you hear of the administrator or the person handling an intestate estate known as a personal representative. I don't believe executors are considered personal representatives in other districts. I'm not sure. You would have to check with your attorneys there. But if you hear the term personal representative outside of New York, that's normally referring to a person handling an estate for someone who has died without a will. Now let's get to the juicy part. The beneficiaries, distributees, and creditors. So a beneficiary is someone named in a will or a trust to receive a gift granted through that will or that trust. A distributee is someone who stands to inherit from an estate by a person who does not have a will. That means that it's determined by law who inherits. That is a distributee. And creditors, believe it or not, are able to bring petitions. They can't necessarily become fiduciaries. In some instances they can, but mostly they cannot. But they can bring a case in surrogate's court for someone's estate to have the estate done. So who are the beneficiaries? A charity would be a beneficiary because someone has to name a charity in their will or in their trust. An heirship loan company. Wow. Heirship loan, you always hear, there was a commercial that said, "It's my money and I want it now." Well, that applies in the world of surrogate's court. And once someone knows that they have an inheritance possibly on the way, they are able to take these contracts out with heirship loan companies, they're called assignments, and assign a portion of their inheritance to this company. So this company now becomes an interested party in the estate. Trust me, I'll deal with them on a regular basis. So just know they're out there. Then other beneficiaries and distributees, this falls on both sides of the line, are incapacitated persons. That's someone who is not able to protect their legal interest or make their own decisions. You have people who are disabled from birth. You have a person in jail is considered an incapacitated person. And also there are minors, people under the age of 18. Beneficiaries or distributees who passed away after the decedent. You also have family members who are missing persons, and you have situations where a decedent's family members are not fully known. Like if you only know your father's side of the family and you don't know anyone on your mother's side of the family, you can't file a petition in court and say, well, they never knew him at any point in his life, so they shouldn't get any money. That is not how it works. The father's side and the mother's side, if there's no will, and depending on who, whether the person was married or not, had any children, the family tree comes into play. You can't do half the family tree. And this is where the problems really get interesting. But anyway, when you have an incapacitated person or a minor, or in some instances, post-deceased distributee or beneficiary, any missing persons and any unknown families, the court brings in additional parties to handle those rights and to assist the court in investigating the facts. So a guardian ad litem is the first one that normally comes in to represent the rights of an incapacitated person, a minor, a missing person, unknown family member. Sometimes a post-deceased distributee or beneficiary has an estate of their own, and their executor or administrator can step in place. So not always is a guardian ad litem appointed. Also, there's the public administrator. In New York, we call them in New York City, we call them public administrators. Sometimes it's the county attorney, depending on your jurisdiction, who steps in on behalf of they handle the administration of the estate where there's no family member or no one to do that. When I mentioned the creditors, sometimes if there's no family member to come in and handle the estate, a creditor will put in an application for the public administrator to administer the estate. And the next party is the attorney general. The attorney general comes in when you have missing persons and unknown family members, because if those missing persons or unknown persons are entitled to a share of the estate, those monies are paid over eventually to the estate, and the estate holds it. I've heard it said that at some point, if the person never shows up, there's a way where the state gets the money. So we're not going to go into that. We're not going to digress, but that's why the attorney general is important, and they take their job seriously. This topic is an area of woe in the practice in surrogates court. So if you step away from this with knowing one thing, it's search for your family members now. If you're putting together an estate plan and you have missing family members who would inherit had you not put together a will, track them down now. Makes it a lot easier. If you remember nothing else, remember that. Okay, let's talk about the assets. As I mentioned, assets can be real property, it can be personal property, and of course, there's intellectual property. So there are also assets out of state that you have to consider. And if you have assets outside of the state where you live, there's going to 9 times out of 10 be a second estate opened up. And sometimes that's called ancillary. The laws are different. In New York, we call it ancillary. Other states just say file the estate, file it in both states. But there's the estate of origination. That's where the person resided. Their estate is filed there. And then another estate is filed where the additional assets are. Now, when you're specifically talking about royalties, they're different assets, because when a person passes away, they're still doing something. Property is sitting there and you still have to pay taxes and insurance. But royalties, there's money coming in. It's almost like an ongoing business, but there are contracts in play. There are agents in play. And you want to find out exactly what the terms are in the contract for how does this continue? How does the royalty payments continue? And how does that apply to your estate? Or if you are handling an estate for someone, how does the contract for the royalties, how does that apply to the estate? So you can have an executor or an administrator who has the right to handle these royalties, just to get them transferred out of the name of the decedent. But there's a whole bunch going on. So first you're handling the payments and you must account for those payments. So are you using the royalty payments to handle the state costs? I don't know if that's the first thing that you want to do as an administrator or an executor. I always believe that the royalties, I believe that they should be held until you find out what the contractual obligations are on those. So I just wanted to mention that because I do know who the audience is here. You also have ongoing businesses. Normally with surrogates court, you have to request permission. There's a petition to get permission to continue an ongoing business. Most of the time, though, you're trying to shut down or transfer the ownership of the decedent to, if they're partners or if it's a corporation. Sometimes, again, you're talking about contracts outside of the estate and how do those contracts impact the administrator or the executor as far as holding on to the money, receiving the money, and applying those money to the estate costs. A turnover proceeding, I wanted to note this here, is what if there are assets of the estate that the administrator or the executor is having difficulty obtaining? Someone is saying, nope, it's mine, I'm not giving it to you, they gave it to me, but yet there's no title or whatever. That's a litigation proceeding called a turnover proceeding, and I'm not going to go into detail about that, just so that you know it exists. And there are other contractual rights out there that a decedent may have been involved in that is not clear cut. And the first thing I would say is to bring it to your attorney's attention and dig into it, get to the bottom of it. So I guess we're doing good on time, but I'm going to keep up a good pace here. All right, let's talk about the settlement. Who gets what? The settlement of an estate means that all parties have been identified and found, and if not, like the public administrator or the attorney general has been brought in to handle their assets, and all administrative expenses have been taken care of, and all debts have been taken care of. Then you're ready to settle the estate. Settlement of the estates is first letting the court know what are the assets of the estate, just to make sure that you've paid the court the proper fee. So let's say that you started in the estate and it was only, let's say, 100,000 when you started out, and then you found out there's a lot more money. Court's like, you owe us some more money. So you pay the higher filing fee when you file the inventory of assets. If you paid the fee that's appropriate from the beginning, then you just file the inventory of assets, and the court will then give you whatever documents that you need, such as additional certificates and stuff like that. Without the inventory of assets, the court puts up a brick wall. There's nothing that you can get from the court until you provide that inventory of assets, right? Now, there are distributions that have to happen. That's after everything is taken care of. But when you give before you can give a distribution, the fiduciary, being the administrator or the executor, has to give an account of what the estate brought in, what the estate paid out, what the estate has left over, and how that is to be distributed based either on the terms of the will or according to law, if there is no will. There are a lot of fights in this area. we wish everything was kumbaya, but it is not. Okay, this is a hot area, and it's actually the area that I specialize in because so many fights going on. The accounting is just what it sounds like. You're putting out a financial report, and you're showing the distributees or the beneficiaries that apply to that what was collected, what was paid out, what's left, and how it is to be distributed. Informally, meaning not in court, for a distributee to say, okay, yeah, that's good, give me my money, they must sign a receipt and release. The function of the receipt and release is to release the fiduciary, that's the administrator or the executor, from their duties as far as that distributee is concerned, meaning that they can't come back and say, you did this wrong, you did that wrong, and I'm going to put in a claim on your bond. I skipped bonds for a reason. I'm gonna put in a claim on your bond, or I want you surcharged or something like that. It stops the fight there. It says, okay, I received this and I release you, and the executor or administrator must receive the receipt and release before you get your money. Yeah, it's for their protection. In a fight where you're going to court, it's the court that releases the fiduciary, the administrator, the executor, from their duties after everything is taken care of. And it's by court order, and the court orders, okay, you pay this to that person, to that person, to that person. And that is how the executor or administrator is released. Now, I went through that very quickly because I want to be able to answer questions, and I couldn't determine what questions would be out there. So, Deborah, how am I doing on time?
Doing great on time. We do have a couple of questions here, and feel free, everyone, should you have any questions, to put them into the Q&A. The first is regarding the royalties, and this person is asking, if the value is unknown, does that mean that the estate has to be presumed to be greater than 50,000? In their experience recently was that they had to go through a full probate because there was an asset, and even though there was nothing else of value, there was still this sort of question mark asset, I guess, of how much it was worth.
Going through a full administration gives the administrator power to investigate and to find the assets, and to find the value of the asset that you know about that you couldn't get the value. It gives the administrator the power to inquire, but not the power to collect. 9 times out of 10, once the value is determined, the administrator makes an application with the court and says, okay, judge, here, I know this is the asset, this is where it's held, this is how much it is, may I now have authority to collect this? And it increases the value of the estate. So 9 times out of 10, you have to pay an additional fee just to get this ball rolling. And then once you actually collect the asset, because sometimes there's interest involved, then that can again increase the value. But to answer the question, yes, you would have to, it's the easiest way to do it is to file the full administration, because you need the power to investigate and to find it. And then you just go back to court once you know the value of it. So it sounds like a headache, but it's the safest way to approach it and to protect the estate.
Got it. Okay. We have another question here. What happens if you make the will while residing in New York State, but later change your residency and you move out of New York?
The state where you move to will probate that will, because it's still your will. You just, you made it when you were in New York, and now you're living in Kentucky. And so now the Kentucky court will probate that will. And let's say you still had assets in New York. Your initial probate the will will actually be filed in Kentucky, and then your executor would file an ancillary estate in New York to handle the assets that are in that state. So it doesn't matter. You can get your will done wherever and move away. As long as you have that original will to be filed with that court, you're good to go. So you don't have to change it again.
But then would they be applying the law of the state where you pass away, or the New York law where you had written the will? Because could that impact, or maybe you tell me, could that have an impact on how the will is interpreted?
If there were an impact involved, let's say that the state where you're moving requires 3 witnesses instead of 2. And in New York, it requires at least 2 witnesses. Then the courts, it's likely that the court where you've moved to will say, okay, in our state, this would not be a valid will, but being that this will was drawn in New York, let's look at New York law and see if that was a valid will for that jurisdiction. That's what I've run across, but I haven't run across cases for every state and every jurisdiction. Sure. So but that's what I've run across, is that the new home state will interpret the will according to the laws of the state where it was drafted, if there is a conflict. If there's a conflict.
I see. Yeah. Okay. I guess it's something to check when you're moving, to kind of just take a look at your paperwork at that juncture. I don't know.
When you're looking at I don't do estate planning, but when you're looking at putting together a will, you're basically saying, this is me, this is where I live, this is who my family members are, this is what I have, this is where I'm leaving it to them. And then it gets a little hinky if you're leaving like businesses and things like that, because you're not relying on contracts, but it involves other contracts. And that's where you could run into problems. But as far as the will being valid, unless there's some marked difference in the requirements for New York and somewhere else, you shouldn't really have a problem with the will. The will still stands. I have family members who go back and forth from the South and New York, and have assets in both places, and then they pass away, but they're down there, and the assets are here, and the will was drawn in Timbuktu. Who knows? As long as you have the original will, I'm going forward with it.
Okay. Okay. Somebody is asking, and maybe this is related to the previous question. They're asking if the value of the royalties are assumed over a certain period of time going forward, or do they look to the past? So I guess really talking about how a court or within this process, if an asset is a copyright, how is that being valued?
The first value that's looked at is the value of the assets at the date of death. But this is an ongoing asset. This is an asset that's bringing in additional funds. I don't want to get into taxes, but that's income, and some income is considered an asset of the estate. And is that income taxable, or is it not? That's why I had to mention taxes. So to value the estate, when you're initially filing the petition, you're looking at the value of the assets at the date of death. But that doesn't mean that the estate is not increasing in value. And the royalties, because remember, the royalties if the royalties were being paid to the decedent, now the estate is collecting those royalties, which is increasing the value of the estate. But I think the issue for valuing is when you first file, and then taxes kick in as to what's the value of the estate. Well, whenever you're paying the taxes, okay, this is the value of the estate, but is this now income? Is this taxable income? And I've always looked at it as, let's get this out of the name of the decedent into the name of whoever's supposed to get it, so that they can handle the tax issue instead of the estate. That's my MO. But that doesn't happen quickly. But my idea is for the royalties that are coming in, while the estate will absorb that over time, my goal is to get the assets transferred. If those royalties are supposed to go, let's say there was a trust set up for the decedent's children, or I don't know, a foundation or something like that. My goal is to get this copyright or these royalties transferred over to whoever's supposed to receive it, so that the estate is out of the picture. And that's the goal. But always keep taxes in the back of your mind.
But I can, if I could just ask one more question about the valuation, and if not, you could just tell me and move on. I'm always stuck on that point, because it seems to me that it's not so easy to value a copyright. And that, from what I understand, you really have to get an expert to value it for you, or it has to be a third party because you want it to be objective. So this now became what is a simple question of how much money is in the estate becomes a bigger process, more onerous. And who pays? Is the estate paying for that? Is that like, if we have to hire people to value things, is that coming out of?
Yes. And that's another thing. I think we spoke about this earlier, that whoever you choose to be your executor, that you make sure that there is some funds, either they have the money to get the ball rolling, or you've left some kind of fund where they can access immediately, like a joint account or something like that. Because to hire professionals to evaluate, I have a famous case that I'm on. I can't mention, the person, but very famous case. And the royalties were being stolen. They were stealing the royalties. Oh my God. Could you imagine them trying to backtrack that? Oh, right. For years they were stealing the royalties. And to bring in someone to value the royalties, where do we start? We started from the date of death. That's the hard and fast. You're starting from the date of death, and then you're moving forward to see this should have been received by the estate, but it wasn't. So just to answer your question, I know I went off on a tangent there. No. Okay, just to answer your question, the first valuation to determine the value of the estate when it's being filed is that it's like a snapshot. It's not a moving picture. It's not a movie. It's a snapshot of, at the date of death, what did the decedent have? And then, do you want to bring in an appraiser to do that? Sometimes you can't bring in an appraiser when you're first filing, but the appraiser must come in at some point. But when you're first filing, I may look at the royalty statements and say, okay, here's one ream. This is one copyright. Here's the other. And at the date of death, this was the value. And I'm doing it, looking at the statements and looking at everything else and saying, this is the value at the date of death. But once you bring in the professionals to appraise it, you're coming up with more money. And again, it turns it, is it income? Is it taxable? And I prefer to keep, when you have royalties going into certain accounts, and normally there's like some kind of business entity accepting those funds, I prefer to keep that in place until we're at the point of being ready to transfer the assets. I prefer not to touch the royalties, because to account for that after you've taken money out is a nightmare, capital N.
All right, we have another question here. Is what happens if a trust and will asset distributions don't match each other?
Okay, I get that.
I don't completely understand the question. Maybe you can say the question in a different way. So I know what you're saying.
It sounds like there is a living trust. So a trust is set up during a person's lifetime. Either it's revocable, meaning that the person who set up the trust can change it, or it's irrevocable, meaning that that person can't change the trust that's set up during their lifetime. and the person passes away, and a will was done probably by someone who doesn't know what they're doing, because they know it's supposed to be a pour over will to pour over whatever didn't go into the trust, but they probably just did a crazy will, or the person never got a pour over will and they had a prior will before they set up the trust. I really think this is where the question is going. If the trust owns the asset, the trust governs. Any asset not owned by the trust will be governed by the will if the will properly covers it. So let's say that the will was not properly drafted and does not have a residuary clause. A residuary clause is the part of the will that says, I leave the rest and residue of my estate to all of my children to be divided equally between them, and I hope that they live happily ever after. Yeah, that clause. Some wills are drafted without that. So what you have are gifts that are given and nothing to take the pull to catch the rest and distribute it. So then that means that the what's not specifically gifted will be handed by intestate law, by administration. And so let's say that you wrote your Uncle Harry out because he was mean to you, when you were young. Guess what? If Uncle Harry is your distributee and you didn't have a residuary clause in your will, and it wasn't handled, and the asset wasn't handled in the trust, Uncle Harry gets the money.
Yeah.
So that to answer the question, what governs? If the asset is not covered by the trust and the asset is not covered by the will, then intestate law, administration law covers it. If there's a residuary clause in that will, normally the residuary clause would catch any asset not named in the trust. Good question.
We have a question here. Is there any situation where there could be co-executors instead of just one in the case of two siblings?
We talked about this. Okay, answer, yes. If the person who drafts the will tries to make more than two executors, I have learned from experience that the court can say, no, we're only going to have two executors, which makes sense, because I could tell you tales of woe about co-executors and co-administrators, but it's the world we live in. So it is definitely a thing to have two administrators or two executors. You run into humongous problems with the bank as far as the estate checking account, because some banks just say, no, we're not going to have two people signing it. You need a court order for that. And then the bulk of my current caseload is co-executors or co-administrators suing each other because someone's living in one of the assets, or someone has access to one of the assets, or someone isn't telling anyone anything, and years go on and the estate is unsettled and no one's speaking to each other. And so you have your lawyer call mine and we'll settle this in court. Who gets the money from the estate? The lawyer. Because everyone's fighting.
I never thought of that too as being a problem. Someone just living in an asset.
Yes.
And you have to deal with, I suppose, removing them.
Yes.
And that's not so easy. It's another reason to have an attorney to do this work. Another question here. Somebody's asking if you could explain the letters testamentary.
Sure. Letters testamentary, when you put in a petition with the court for probate, you're probating a will, the court determines that the will is valid. And if the court determines that the will is valid, it will issue letters testamentary to the executor named in the will, or the person who's petitioning. So letters testamentary are specific to probate of a will in New York. It's not letters administration. It's not letters trusteeship. It's letters testamentary, which only applies to an executor?
Let's see if there's another. Okay, feel free to pop in more questions. I'm just gonna ask one question of my own. Again, I don't know who on this call is already managing, an estate and trying to go through this process, who's preparing to potentially go through this process one day, or if it's people just planning their estates and just taking a look at sort of the landscape. So I'm just wondering, for those authors who are in the planning stages, when you're looking then to have an executor over your will, or this person that's going to be in charge of administration, what in your view is sort of the right kind of person? How do you pick somebody? How do you pick the right person?
Number one, I would say someone who is professional, and that doesn't mean that they have to have a profession, but just someone who knows how to deal with banks, and someone who understands if I love my accountant. I don't touch taxes. I call my accountant, I FedEx a document to him, and that's it. It's a beautiful relationship. But I know I'm not doing any taxes. So I know that I have to hire someone to do the taxes. I don't touch the real estate. No, 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 no. I have a real estate attorney. I hire that real estate attorney to do whatever needs to be done. If you need to evict someone, go ahead and do it. Staying in my lane. I know what I'm doing. That's the person that you're looking for. The person who's resourceful and knows, I can't do this. I need to bring in an expert. I need to bring in a professional. Someone who knows how to keep a calendar. Someone who knows, because you need the calendar for the court deadlines. And there's another deadline, just to throw it out there. I'm going to segue a little bit. 9 months after the date of death, you're supposed to file final income taxes. You normally don't have any kind of letters 9 months from the date of death. My advice is file them anyway. The IRS or New York State is going to kick it back and say, oh, you don't have the authority, this and that, but at least you have them receiving the taxes before the deadline. It's not always an issue, but sometimes it does become an issue. So you see how I knew that off the top of my head? You want someone who knows how to go and ask questions. So the person doesn't have to be professional. It just needs to be a person who knows to go get a professional. Next thing, someone who's honest. I mean, someone who knows, my grandmother taught me, not your money. Okay, so I'm handling this, but it's not my money. There's a way to handle not my money. Okay,
Right.
You want someone who understands that difference. It's not their money. That's why I talk about honesty. And I really think those are the two major things. And I'm gonna put an asterisk there. Always have an alternate executor, just in case something happens to this fabulous person who you've just named in your will, just in case. And
That was actually one of the follow-up questions here. What if my executor passes before me?
yeah, an alternate executor. When I was doing estate planning, I kept finding people's like, I have no one else. Can I use you? And there are rules that apply for a lawyer who serves as an executor. It's just like 2 affidavits you have to fill out. But there are rules because you're also a fiduciary who's able to make a profit from the estate. So that's the point of that. But if you have enough assets, you could name a bank. But I think an alternate, here's the deal. If you run out of executors, let's say I just had a case like this, everybody passed away. So the person who's appointed is called an administrator, CTA. That means with the will attached in Latin. Okay. So it's an administrator who handles carrying out the terms of the will. And depending, I'm just giving this to you loosely, it can be one of the beneficiaries named in the will. There's a statute that determines this. So it can become one of those people because they're interested parties, but it's someone other than who the decedent picked. So just in case everyone dies, the law steps in and says, okay, maybe one of the beneficiaries could do it, but you've got JoJo who has a little drinking problem. Okay, you've got Amy and she's got sticky fingers. So someone has to come up and say, I have a client who just said, get a bond. Whoever it is, just get a bond. Well, bond protects the value of the estate in case the fiduciary does something wrong.
Oh,
Okay,
wow.
so the bond company will go after the fiduciary for the money, but cover the money payable to the estate.
Wow. Someone's asking here how the executor gets paid now that we've established that they have to do all this work.
The commission, there is a statutory commission for both executors and administrators. It's not just the executor. Administrators get paid a commission. In New York State, it's by statute, and the value ranges from 3% to 5%. Well, actually, it's actually 5%, and then it goes down. It's a scale. So it starts at 5% based on the value that you're dealing with, and then it steps down. So the commission is payable once you have reached the point of the estate where all the assets are collected, all of the debts are paid, the creditors are taken care of. Now, even though it's an administrative expense, and administrative expenses come before debts, but you have to go through the entire estate before you're entitled to collect that commission. If you collect it before, hot seat, accounting in court, here comes Ms. Barnes, and you're going to negotiate that money and you're going to get some back.
Well, I mean, it's almost, I guess if I could follow up with that, I'm starting to feel overwhelmed on behalf of our playwright. It seems to be a large job, and how much of this can people actually do it on their own without hiring attorneys? Or is there a point at which an attorney really needs to be hired? I mean, I'm saying this, of course, to an attorney that does this work. So I guess, yeah.
I am capable of giving you an honest answer. The honest answer is, if you can navigate the petition process of applying for letters testamentary, let's say if it's for a will, if you can navigate the torrential waters of surrogates court and all of the distributees, that's people who would take from the will, who would take from the estate had there not been a will, and all the beneficiaries get along, cooperate, they sign all the waivers and documents that you need them to sign. Yes, you can do it, as long as you have no problems collecting the assets of the estate. You don't need to do like a turnover proceeding or sue someone or anything like that. Then you can collect the assets of the estate, and then you handle all the creditors and the debts. And when it comes time to put together that accounting, you put together an informal accounting and give them to the beneficiaries, and they sign off on the receipt and release. Yes, you can. You can navigate this. It's a puzzle. And it has like one of those little tiny 1,000-piece puzzles. It's a puzzle. And if you're good at puzzles, you can do it. Take your time, find the pieces, put it in there, hire whatever accountants, CPAs that you need, people to do appraisals if they're to appraise any assets that have value. Keep your documents, keep copies. And if everyone plays nice, yes, you could do it without a lawyer.
And how long does that take then, on average? Is there an average? Is it even fair to ask that question? I mean, what is someone looking at? Yeah.
Post pandemic, post COVID, I would put, and depending on the county you're in, I'm not going to name any counties here. It's being recorded. not going to name any counties, but depending on the county you're in, I'd say honest answer from beginning to end with an estate with assets such as royalties or an ongoing business, you're looking at least 16 to 18 months.
Okay.
Yeah. Now, if you complicate that with any of the slower counties, in some counties, they're not slow, they're overwhelmed. The courts are overwhelmed. Wheels of justice turn slowly, but some of the slowest ones do the best jobs. So you see, they dot every I and they cross every T. So what can you say?
So it's good to know that it's a process. It's not 2 months. It's closer to 2 years. Wow.
Oh yeah, definitely.
Wow.
2 months.
Is anyone else shocked? I feel so uninformed. So we're just about at 4 o'clock. I don't know if you want to offer just a final thought to our listeners. Just what's the one thing you would tell them if you only take away this is my piece of advice from the other side of our affairs.
If you take only one thing from this entire session, it's if you're going to get a will, have it done by a lawyer, because there's a rule called due execution in New York. When you're looking at the validity of a will, you could have a will that was drafted by a lawyer, but if the lawyer didn't conduct, or a lawyer did not conduct the execution ceremony of the will, you do not have due execution, and it's just another hurdle to jump over. And when you don't have lawyers do the wills, remember I was talking about the will without the residuary clause? It's just one example. I make money when those wills come through, okay? Because they're wrong. And it takes so many legal hours to fix them. I put out good energy, I'll be fine. You guys go get your wills done by lawyers. It's okay. I'll find business. It's okay. But get the will done by a lawyer. Have the lawyers supervise the execution of the will, even if you're going to move, even if you're going to change it. And then we didn't touch on this. Let me touch on this real quick. Remember the safe deposit box? Put the will somewhere safe so that someone cannot destroy it. You never know. There's a story I'm not going to tell about a will that was destroyed in the presence of a drunk cousin who was not a good witness, and therefore that will did not go through. It went to intestate.
Oh my God.
He ripped the will up. Yes, put the will somewhere safe, like a safe deposit box, where someone who would not take issue with it can't get their hands on it.
So that you don't give Miss Barnes another story to tell.
Yeah.
Thank you so much for being with us here. If people want to reach out to you, what would be the best way to do that?
You can reach me from my website. I think that's the easiest way, because there are different ways to contact me. And it's tdbarneslaw.com.